Good evening, everybody, and welcome back to another Wednesday webinar with the Property Law Alliance. It's so good to have all of you with us, especially with all the so dangerous out there nowadays with COVID, and I hope that you all are keeping safe. It's good to see Bruno and Solna. How are you guys doing? Solna, how are you doing?
Very good, thank you. I must say, I think on the edge of our seats, we should actually do a special edition on the functioning of the Constitutional Court and what's actually happening with the whole Zuma thing, because I am absolutely on the edge of my seat, and it's freaking me out on a whole new level to realize there are people that's getting this information overload that makes the law look like an absolute circus. And actually, like, we have these long arguments between attorneys about this legal aspect and that legal aspect. And I mean, you guys definitely share my sentiment. This is one of the most interesting tests on our constitution that we see. And at the same time, yesterday, watching an argument in the Pietermaritzburg High Court, I thought, at least now we've heard things about eviction, very famous eviction cases like Blue Moonlight Properties and Saratoga Avenue, argued to keep Zuma out of jail. Now, I just want to say, full circle property law, guys. If we are using those cases as case law, then we know we are playing in the fun field of the law. But so I'm good, thank you, Chris. How are you?
I'm well. Bruno, how are things going with you?
No, I'm very well. It's still unfortunately encountering quite a lot of people that are contracting COVID, so that's quite unfortunate. But as Silna mentioned, at least there's been some entertainment value from from our Facebook and WhatsApp groups recently with the Zuma thing. But yeah, definitely on the edge of our seats. It's just shocked that, I suppose to one degree, people want to know that the law has a level of finality to it, whereas other people like to know that there's always recourse. So everyone is very interested by this because there's always two sides to this. And yeah, it's just like, it's just entertaining.
I'm just grateful I'm not the judge in Pietermaritzburg. I looked at him yesterday and I actually said, if I was that judge, the only correct answer is I will reserve my judgment until, next week, Tuesday, give it about 12 in the morning. I don't think I would, be brave enough to give an order, because damned if you do, damned if you don't. I mean, you can't.
Absolutely.
So that's,
Absolutely.
I think, why I'm saying I'm well. As long as you are not that judge in Pietermaritzburg, you are doing amazingly well.
Well, what's guaranteed, like you both have been saying, is that it is entertaining. It really is, and informative to keep up with it. But on to more entertaining things, I would hope, and that's tonight's webinar. But before we begin, I just wanted to mention that we are now on the Property Alliance page. And from next week, we're going to be moving over the webinar onto the Property Alliance group. We will drop all the information in a link on our posts, so that for our viewers and our loyal viewers, you can go over and view us next week, Wednesday. But without further ado, let's begin. We've got really interesting questions today, and quite a few of them at that. The first question was asked by Happiness. And Happiness wants to know, she says, if you need to change the ownership of a house, do you need money? And if yes, how much money do you need? And lastly, where do you change it? I have a second part to this question, but Solna, can you please provide Happiness with some happiness here?
Definitely. Happiness, thank you so much for this question. I think this is a question that is not asked often, especially in investor groups and stuff, because I mean, this is what your typical property investor does for a living every single day. But this is the kind of education that I am deeply passionate about, that we need to get out. So thank you so much for asking this question. Property ownership in South Africa is regulated very much by Dutch law. Remember, the South African legal system still to this day is based on the Roman Dutch law system. We are definitely progressing towards a truly South African legal system. And we can see that happening. We can see application of Ubuntu and things like that. So we are progressing towards or maturing into our own system, but we're still strongly based in Roman Dutch law. So our conveyancing side of things, property ownership, immovable property ownership, and how that transfers is very strong Dutch law. So how the Dutch law system works and how it works in South Africa is that we have a deeds office. The deeds office has a deeds registrar of deeds. This is a person very similar to, we can say, a judge or the master of the High Court. That's a person that has to make a decision on every transaction. Is this legal? Did you pay your rates and taxes before you selling it? Are you paying your tax on this property? And is there an agreement between the parties that it will go from me to Chris? If it is all in order, lekker, then we transfer. And the title deed, a title deed is the thing that says this property belongs to this person. And very often a title deed has a few other things, your servitudes and caveats and stuff. So say, for instance, you have a bond, it will reflect on the title deed because it must say, we can't just sell this property. There's a mortgage bond in favor of a bank. We can't just sell it and say, sorry, bank, not looking good for you anymore. You didn't get your money, but also the property now belongs to another person. That's why we're recording all of that on the title deed. Once you sell the property or transfer to another person, the content of the title deed stays exactly the same, but it says now all of this history is moving to the purchaser of the property. And you will see title deeds, some of them date back to way back when, and some of them still have Dutch in the title deed, especially on your servitudes and stuff. It will still be and could still be in Dutch because it stays the same. So to your question, to transfer property from one person to another, from what I'm hearing from your question, Happiness, it doesn't sound like a sale per se to me. It sounds like you want to change the ownership without an actual transaction where you are selling the property. So say, for instance, I have a property. I don't want it on my name for whatever reason. I want to put it in my friend's name or whatever the situation, my sister's name or my parents' name. How do we do that? You need to transfer the property, and that you need money for that. Transfer cost is done, you have to transfer through a conveyancer. No other person may do that. Many attorneys are also conveyancers, but all conveyancers must be attorneys, if that makes sense. So most attorneys will have a conveyancer, and attorneys can do this for you. Cost depends on the value of the property. So we have this sort of suggested cost that we can charge. We can charge more, we can charge less, but there is a bit of a guidance on how much we must charge for it, depending on the value of the property. If the property is over R1 million, you also have to pay transfer duty. That is tax that you need to pay to SARS. It comes to the attorney's account, but we pay it to SARS directly, and we can't do anything about that amount. That is set by SARS, and we can't change that. So there will be a cost involved. If you are selling the property, actively selling, obviously, then there's going to be actual money flowing in the transaction. But if it's not a sale and just a transfer, I suggest that you talk to a conveyancing attorney to get a quote, see how much it's going to cost. And once the transfer is done, transfer at this stage is super delayed. Usually took about 4 to 6 weeks at this stage. I don't even want to say, it can be anything from 6 weeks to 8 weeks, and if it's in Pretoria, we can't say. So I hope that helps, Happiness.
Thank you, Sona. The second part, well, it's linked to this, and there's also another question as well. Is I've heard of people buying homes or land in rural areas, and they bought it like, let's say, a good 20 years ago, or whatever it may be, and then later discover that the ownership has changed on the property. Like it's just not theirs. They bought it, but it's not theirs. It's not registered under their name or whatever it may be. Lebogang asked a question very similar, well, in line with what I just said now, which is, my brother wants to sell our late mother's RDP home. What can I do to stop him? Bruno, can we tackle this one?
Cool. So two parts to that, and so they do tie into a certain degree, because I think the first part of your question ties into sometimes what happens to RDP houses. And so what Silna was speaking about was the formal way that properties have to be transferred. They have to, right? That's how ownership in South Africa actually passes. So it's almost a deed of delivery, and for there to be that contract or that transfer to actually take effect, there needs to be that deed of delivery with most things, be it donations or sales or whatever the case is. So that's legal terminology, but basically to say that you cannot complete the sale unless you've delivered whatever you're selling, and deeds office is required in order to do that. It records ownership, so it's prima facie proof of ownership. So if to a general degree, most people agree that if it's in the deeds office, it's been done properly. Now, unfortunately, and this also going to what Silna was saying, I think the problem is there's a lot of misinformation out there. And when you get deeper and deeper into rural areas, but where there is land ownership, so I'm not speaking specifically of tribal lands, because that's very different, because that's actually, that actually vests in the authority there, and they dealt with differently. But I'm referring specifically even to areas that are very close to cities, but where there's a lot of information about how properties are actually sold. So you typically tend to find that because these properties are lower value sometimes, you find people selling them for 50,000 Rand, 20,000 Rand, whatever the case is. And this makes it very easy to for money to change hands. Because it's not, so for example, if you look at inner city where the property values are 400, 500,000, with that amount of money, you typically find that banks get involved, conveyancers get involved, nothing's done in cash. So it becomes important to get advice, and the misinformation disappears. But if you're dealing with lower sums of money, people tend to do these transactions themselves. And the effect of this is that the sale is never actually concluded. And at some point or another, you find that these properties actually get sold to somebody else. These people buy the properties, actually take transfer of the properties, and then go and try and evict the people that have paid purchase prices thinking that they've bought it, but where in fact they haven't. And that's the misinformation that I think Silna is referring to when we say that people need to, I mean, share this video, make sure that everyone knows about this, because this keeps happening, and it happens very, very often. Now, just to give you examples, and this is where it kind of touches on your question on where I've noticed this a lot, is there's a lot of questions on RDP houses, right? Now, remember, RDP houses that are given by the state to you, if memory serves from the last time I checked, it has to be in a period of 8 years in your name. Up until that point in time, you cannot sell it, right? So first issue that I find is people trying to sell houses within the 8-year period where they're not actually allowed to sell houses. So they get it, they sell it, they walk off somewhere else, they stay owners of the property, and the person that bought it is not the actual owner. What sometimes happens with those properties and any other properties that's sold in that way, whether it's RDP or normal, when the seller, who he might even be honest and think that he's selling it, receive the money and think, oh, the deal's done. But when he passes away, now it becomes a problem, because when executors come to deal with their estate, they start looking at this very differently, and they start trying to deal with their estate, deal with the property, try sell the property in order to raise funds to pay any estate debt or whatever the case is. And now you're fighting against the party that was never involved in the transaction, and that has, for all intents and purposes, all rights to say, no, this property is ours. And the worst part with this is sometimes it's cash that exchanges hands. So there's not even a paper trail to say, well, I paid the purchase price because here's a contract and here's proof of payment. So look, everything's here. all that we forgot to do was do delivery, but I can enforce that now. Because then the problem also becomes comes with a he said, she said environment where it's, yeah, but I paid 10 here, 5 here, here's a little slip where I deposited into this account, then the guy owed money to that guy, so I paid that guy. And as soon as it starts getting to that point, it becomes impossible to trace. But because delivery hasn't taken place, it's almost like the onus is against you, which makes it necessary for you to have to prove this. So very dangerous to not follow the proper process for transfers. I can name a million examples where this has gone bad. And now to the viewer's question, just regarding stopping the RDP house being sold. So for starters, it has to be a formal process. So, I mean, that's already one way of stopping someone, is by saying, well, unless you're doing it the right way around, you're not doing it at all. Second thing is, it has to be over 8 years in the person's name. So if I'm assuming that his mom has passed, but that's a bad assumption. I'm not actually sure, because if his mom is alive, that would mean that this property can't be sold without his mom's consent. So you're good. And it has to be past 8 years. If the mom has passed away, different story, then you need to look at the laws regarding succession, who's actually entitled to sell the property. The executor would have to sign it off. So there you can stop the property from being sold until the executor's dealt with it. Ultimately, the only way that his brother would be able to sell the property is if he's actually the only heir to that property. The property will become his inevitably, and no one can stop him. In that case, it might be difficult to stop him because it's actually his property to sell. Short of that, you'd be able to stop him in plenty of ways.
Practically, Bruno, if I may, I think practically to stop that, you would agree with me that the only option would be to approach a high court if he doesn't want to see, if he doesn't want to hear what you're saying. Only option would be to approach a high court to obtain an interdict, right?
Yeah, look, I suppose it's the only way that somehow you could enforce it. The problem is if you do it behind somebody's back. Apologies, my screen went off. If you do it,
if you just don't want to answer the question, like you can say, no, so I don't agree.
No, but I do agree with you. So the high court would be the only right way of stopping him. The problem is if the brother goes behind everyone's back, does this transaction, like signs an affidavit at a police station and takes money, ultimately he's going to get away with committing fraud. The purchaser trying to move into the property, ultimately you just turn around to him and say, well, sorry, you don't actually have anything valid here, so you're not allowed to move in. So the only right way of doing it is through an interdict. If the brother does decide to do it behind anyone's back, the problem is that it's never going to go through. It's never lawful. You just need to stay on top of it to make sure that nothing actually happens. The person doesn't move in, live there for 20 years, and then you try to kick them out, because that's going to be a disaster.
I think you said something super important just now, Bruno, that we need to highlight. I'm taking out a highlighter. To do an affidavit at a police station, the police doesn't care about the content of the affidavit. You can go and commission a Christmas card for your grandmother. They can commission that. Commissioning doesn't mean this makes it a legal document. Commissioning a document means you said and you swore under oath that the content of the document is true. Now, unfortunately, people lie, so that could be a problem. An affidavit at the police station is not a valid sale agreement. It's not a valid transfer document. It cannot ever override the function of the deeds office. I think that was super important that you mentioned that. Even if there's money, even if there's anything, an affidavit at the police station does not change the legal position when it comes to sale of a property. Now we'll shut up, Chris, I promise. I'll drink tea.
No, I was just very intrigued with how blessed your grandmother was or is. The fact that you commissioned all her Christmas cards.
It's almost
but,
like
but moving along.
just stamp it.
moving along, we have a question by Jen, and shame, I really feel for Jen. She seems to be going through the most at a property that she's residing on. Jen asks, she says, I have a lease on a house until September. The house is in a bad state of repair and only getting worse. The owner refuses to do any repairs as he wants to sell the property at some point. There's water leaks when it rains, which has damaged some of my belongings. Jen wants to know, where do I stand with regard to the damage to my belongings due to the landlord's neglect of the property? Solna, if you want to tackle this one.
Yes, so unfortunately, I wouldn't stay long enough to allow the property to be damaged, to be honest. I think the horse probably bolted by the time there's damage to the property. I would probably step in and advise that, would definitely advise that you act on the landlord's bridge before your property gets damaged, because the problem is any property brought onto a rental property remains the responsibility of the tenant, unless the landlord is grossly negligent. And the problem with a water leak is it's not necessarily gross negligence by the landlord. I've seen cases like a million. I've been inundated in the past about a month with questions from rental agents and landlords in Cape Town, because now it's raining. Remember, they had that amazing drought. It's better now. It's much better now. So they have a lot of rain currently in Cape Town. So I've had quite a few questions. The thing is, if you have a severe leak and the landlord is sending out someone to fix it, but they're not fixing it properly, or it's raining too much, they can't get in to fix it while it's raining. Unfortunately, that's not, in my opinion, gross negligence from the landlord, to the point where you would be able to claim damages from the landlord if your items in the property gets damaged. Obviously, if the landlord says what ifs, it could be, but the better idea would be to place the landlord on terms. Remember, a landlord has an obligation to maintain the property. Water coming through a roof is part of the landlord's obligation of maintenance on the property. You will have to have a look at your lease agreement. Ideally, your lease agreement will have a clause dealing with the landlord's breach as well, allowing you to give him 20 business days or whatever to remedy his breach. If he doesn't, you can then enforce a few remedies. And the nice remedy that would be available to a tenant in a situation like that, where there's maintenance that must be done, but it's not being done, but the tenant can actually get around to fixing it, would be a very nice one. It's the Latin term is exceptio non adem pleti contractus, where you basically say, Mr. Landlord, you are in breach of the agreement. You have this amount of time to remedy your breach. If you don't, I am going to withhold my performance until you perform. And what is the tenant's performance? Rental payment. So you can never, ever, ever, ever withhold rent because the landlord's not doing maintenance. What you can do is you can follow due process, place him on terms, allow him time to remedy his breach. And if he doesn't, and you told him, then you're going to withhold rent. You withhold your rent until he performs. You can do that. Other option in this case is cancelling the agreement, claim the damages then from the landlord. That would be your damages, because now you have to move again. There's a bunch of damages then on your cancellation. Claim damages from the landlord, not just for the items that was damaged. If you can prove that there was actual, proper negligence from the landlord on the damage, you can claim damage from, to the items of the tenant. But I must say that would be a bit of a long shot for me. I would rather focus on either withholding rent and fixing the problem, or I would probably just cancel, vacate, and claim actual proper damages from the landlord due to money that you lose because you have to move again.
No, thanks, Sona. The other thing is, sometimes you inherit bits of furniture and things that you don't necessarily want. So painting that your great grandmom or whoever passed down and then that gets hung on the wall, and then you leave it there, and the rain goes onto it. You're like, never mind that, it's okay if it gets damaged. The landlord's going to pay for it anyway. So, no. I would suspect as well that you've got a responsibility then to actually ensure that your goods or belongings are not in harm's way.
Exactly. Towels.
Yes, which actually is what Jen had done. So well done on that, Jen. Then we're going to move on quickly to there's two questions, very similar, but different as well. And I'm going to move to the first one, which was asked by Mary. Mary says, I signed an OTP with an agent. Now, we must bear in mind that only Mary signed at this point in time. The bond was approved by the bank, and this was obviously now under the assumption that the seller would also sign at a later stage. And the bank had instructed their attorneys to register the property. While waiting for the signed OTP from the seller, the agent informed me that the seller is no longer willing to sell. How do I find out whether the seller or the agent are going ahead with a different buyer? So I don't know if you want to tackle this, or Bruno, which way you do it.
Bruno, do I recall correctly? I actually think you want this one because you have case law for him. Do you want this one or the next one?
Okay, so let me take this one. Unfortunately, the case law isn't great case law, but it is just one of those situations. So the OTP was signed by the purchaser. The seller never accepted. All right, that means strictly speaking, there is no contract. Now, why is this? And people now need to understand the distinction, and we need to keep explaining this because it is very important. Our law does allow for verbal agreements. Our law does allow for tacit agreements. Even in lease agreements, if one party signs and the other one doesn't, but they move into the property, it's still considered to be a valid lease. And you can actually argue it on the terms, on the written terms, despite there not being signature, because the parties tacitly accepted those specific terms, right? And we've done it plenty of times when it comes to lease agreements, where you go to court, you avert that these were the agreed terms, and the courts need to accept it. So the problem with sales of property is the law specifically states that this party signatures, it needs to be in writing, it needs to be signed by hand in writing, and this concept of wet ink, right? So the kind of short, simple answer, the answer with least resistance is, sorry, it's not going to fly. The seller would have to have accepted it in writing, signed, and all of that for the contract to actually be enforceable. Whether he's selling to somebody else or not is almost inconsequential. The estate agent should have also known this. Being an estate agent, they are trained in this. So even from a commission perspective, maybe she might have a claim against the seller in the sense that a deal was brought within the parameters of the mandate. The seller should have actually accepted it and refused to. But that's a claim that the estate agent has. And so far as the purchaser is concerned, it's at best, I suppose, if there were any misrepresentations made by the agent or the seller, maybe there's some recourse if damages were suffered, but definitely not enforcing the sale, right? Where the case law comes in, it's just really interesting because I almost feel like there comes times where testing things like this could pay off. So recently, there was the Eastern Cape a case that Selma and I spoke about just a couple of months back. And long story short, digital signatures in contracts for the sale of immovable properties not permissible. It has to be wet ink, so it has to be a pen to paper scenario. And in that specific case, the court spoke of the one signatory knowing this very well and almost having done it intentionally, knowing that he could back out the contract later by having done this, right? And I almost feel that if the party and everyone criticized that judgment, and I suppose to a certain degree rightfully so, because it created uncertainty, because now it wasn't about wet ink anymore, it was about the intention of the party. Sorry, I don't know what's wrong with my phone today. Sorry. It was about the intention of the party and how they signed the contract. And that's very foreign to us because we've never considered this in the Alienation of Land Act. But it is interesting because if the courts ever did open the door for that sort of thinking, this is a typical example of a situation where the seller knew very well that they represented that they accepted, they allowed everything to take place, and they were acting in bad faith. And now, after all of this, they decide to back off. Would a court consider this to be that they did accept it? Maybe there was an email or some kind of indication. But look, it's doubtful. It's just an interesting notion to think about. If you ever have a very serious case with those facts, it might not be a bad idea to approach the court just to see what happens. But yeah, it's unfortunately your prospects aren't necessarily great.
Yeah. I think that judgment, especially from the Eastern Cape, I suppose we can expect it to be overturned by a higher court at some stage. Because I must say, I don't like the order.
So you don't like?
I don't like that order. I think the court.
Look, so do I, respectfully. I do think so as well. My opinion is that the law should change in this regard, right? I think it is very archaic to require wet ink, especially with authorized signatures. So it's almost a weird way of a court trying to prove a point, but doing it in a way that goes against all other higher courts and all legislation. But the reality is it's a good debate now to have where it's like, you know what, guys, change the legislation. We need to be able to sign electronically.
And I agree 100% with that. I think the risk is application of that case specifically to force almost past consensus. I think, again, respectfully, I think that I erred on that side.
Yeah, no, fair enough. Yeah.
Okay,
So,
Chris,
you don't have to say respectfully because you're always respectful. So I mean, it comes. Yeah. But to move on quickly, this is now that was without a signed offer to purchase. This next question by Belinda is with a signed offer to purchase, and she asked. She says, "I bought a home or a house directly from a seller. We signed an OTP and sent the documents to the bank originator. My application was successful. I finished all the necessities from the bank, got my building protector and life insurance in order. The bank then transferred me to the lawyers." She says a week later, when the documents were with the lawyers to register the bond, the seller contacts her saying she wants to cancel the offer to purchase as she received a better offer. Belinda wants to know, what are my rights and can I sue the seller to perform in terms of the contract? Silna, what say you?
Belinda, I have beautiful news for you. Respectfully, the seller doesn't have a choice. He's going to transfer that property to you. Yeah. That agreement was concluded, and your option is to place the seller on terms. You will see in the offer to purchase, there will be a clause. I promise there will be a clause that says the seller will take all necessary steps to transfer the property. So transfer is an obligation of a seller. So what you're going to do is go look at your breach clause. He will probably be called breach. And he's going to say how many days you need to give the other party to remedy their breach. Then you do a letter of demand. Ideally, this is typically, I mean, a property isn't a 20 Rand thing. So it's really worth going to an attorney for that. I usually talk people out of litigation, but I talk people very much into proper correspondence. I'm not saying you can't write a proper letter, but we know exactly what you do and how and which terminology to use. So I would recommend going to an attorney and do a letter of demand. Place the landlord on terms, so do a Mura letter, a terms letter, place the seller on terms, give him the allowed time in terms of the sale agreement to attend to the transfer, so remedy his breach, failing which, don't threaten with cancellation, threaten with specific performance. So then you approach the court, to compel him to transfer the property, and it gets way sexier. We ask for an extra order that if the seller then doesn't want to attend to the transfer, that the court authorizes the sheriff of the court to attend to signing the documentation on behalf of the seller. Yella, Belinda, I love it. I have a nice answer for you. Usually our answers are sad and like, oh, yeah, no, sorry. We can't do anything. I love it if we can say, yes, this is a clear one.
You've made Belinda's entire year probably with that answer. So thank you, Solna.
And between Belinda and happiness, they made my day. So
well, thank you so much, Solna, and thank you, Bruno. It's been a wonderful webinar with you guys and catching up as well. I just want to urge everybody out there to take the necessary precautions to remain safe if you are going out to work and so forth. For those of you that are at home isolating, go out, get some sun every now and then, and please go and watch some of the previous episodes of the Wednesday webinar. We have something for everybody. But as always, thank you, Solna. Thank you, Bruno. Please remember to join us over on the Property Law Alliance group next week. Like I said, we will be dropping the information on both pages, well, on the page and the group. And looking forward to seeing you next week, Wednesday at 6 o'clock. Cheers, everybody. Good night.
thanks, Bruno. Bye-bye.